90.3 WHPC now presents Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now, learn about the law and how to protect yourself against the loss of your liberty or property, and learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is attorney Kenneth J. Landau, a past dean of the Nassau Academy of Law, and frequently lectures to lawyers on ethics and avoiding problems with clients, and to the public on how to choose and use lawyers. This is Law You Should Know on the voice of Nassau Community College, 90.3 WHPC.
Hi, this is Ken Landau, and welcome to Law You Should Know. Today we have a very important topic of interest to everyone: privacy in the workplace, and especially what the latest developments are. Our special guests are attorneys Rachel A. Morgenstern and her colleague, attorney Nicole E. Osborne. They're both with the firm of Ruskin, Moscou, and Faltischek, one of Long Island's largest law firms with offices in Uniondale and Manhattan. Rachel and Nicole, welcome to Law You Should Know.
Thank you for having us.
You've been involved in this field for a number of years, and Rachel, why is there privacy in the workplace these days?
So when I think of privacy in the workplace in New York, I think about the common law. And New York common law actually provides for no privacy in the workplace, which may be contrary to what most people imagine. At the same time, there are statutes in place that provide for privacy in areas where you would normally expect it, such as bathrooms, locker rooms. If you're thinking about hotels, maybe bedrooms. These are places where you can have a reasonable expectation of privacy. So they're protected from videotaping, audio taping under general business law, and even the penal law. But if you're in a workplace and you take a couple steps outside of the bathroom, those protections essentially fall to the wayside, and you're left in a place where it's permissible to record your employees.
On the flip side, can employees record their employer?
Yes. So New York is a one-party consent state, and that applies in the workplace. Technically, if you're a party to the recording, you can record your employer or a colleague. That being said, just because it's legal doesn't mean it's necessarily advisable. So I would wonder, why are you recording that? Is your intention to use it in evidence in a lawsuit? A lot of time this comes up in the context of discrimination suits. So, for instance, an employee might go and speak with their employer and try to surreptitiously record them using a phone. The question is, how useful will that be in the context of a civil litigation? It's actually been construed in some cases negatively by the court, where the court will think that you were trying to provoke the employer to say something discriminatory, or it might even be seen to undermine your credibility.
And that provoke is an actual is an interesting issue. But we should, unfortunately, everyone has to be on guard about that. Employees, colleagues, and employers. Yes,
there's also the issue of colleagues you mentioned. So not all recording is between a superior and the employer. Sometimes a colleague might be recording you. And while it's permissible, there's also the question of comfort levels in a workplace. And recording someone can make people uncomfortable. It can also be intimidating. And while there are protections in place if you're engaged in protected activities such as recording discriminatory conduct, there are also ways that employers can incorporate rules internally for their company to give notice about what is appropriate and what's expected in the workplace.
Yes, go ahead, Nicole.
And if I could just add, when it comes to employers recording employees in the workplace, it's important to remember, like Rachel said before, this is a one-party consent state. So really, it's video only that is permissible for employers in the workplace. So if they have security cameras and things like that, you can't have audio recording because you'd be violating the one-party consent, right? Because you could be recording two people's conversations in a room and neither of them may know they're being recorded, right?
And the one-party consent is for audio and, let's say, video?
No. So for employers are allowed to do video-only recording in the workplace. Now, it is greatly, greatly advisable that you make your employees aware that the video recording is taking place. But it's just important for employers to know you should not be audio recording office security cameras of your employees. That is not permissible in the state. It's video only.
And are there other ways companies can and should protect themselves against, some of these issues and the privacy issue?
Oh, well, an employee handbook is your greatest protection. So I'd say New York State has lots and lots of rules when it comes to how the employer and employee relationship is to be governed. And a lot of those rules are required to be provided to your employees in writing. A big one this year was that we have the new law. It went into effect almost a year ago today, the Notice of Electronic Monitoring. So this is a document that actually has to be provided to all employees at hiring and has to be posted for all your other employees. I make sure I put the language in the employee handbook as well. But it really lets them know that either they're being monitored electronically, their emails, their phone calls, internet usage, or you intend or maybe one day will monitor them.
And do you recommend employers put the confidentiality language and maybe a non-disparagement clause about clients, in those policies?
For an employee handbook, you might want to have a confidential information policy. But when it comes to non-disparagements or, even a much more greatly tailored either non-competition, non-solicitation, confidential information policy, you might want to look outside of the employee handbook to do actual agreements with your employees regarding those topics.
And does sometimes that include salary, that you ban an employee from discussing your salary with other employees?
That is illegal.
That is illegal.
Okay. So the National Labor Relations Act, it provides rights to employee when it comes to discussing wages in the workplace or, talking about other benefits or rights employees may have, the right to unionize. So no, you cannot ban employees from discussing salaries.
What if you're in a professional firm like an accountant, a lawyer, a consultant?
There's no specific difference that I'm aware of. Now, you can have certain rules regarding management and lower level employees, but with a general prohibition of discussing salaries is per se a violation of the law.
And I know Nicole mentioned the labor law. It's an interesting exception. While you can record in the workplace, there are protections in place for unions and labor organizations. You're not allowed to secretly record them.
And if you, let's say, give a bonus to someone, can you say as a condition of the bonus, you can't discuss it?
No, you cannot prohibit people from discussing their wages in the workplace.
And does that include posting it as opposed to a private discussion with someone?
Like on a website?
Yeah, or one about a website about the employer or just some kind of website?
No, I'm not aware of any right an employer has to prohibit their employees from discussing their wages or benefits in the workplace.
And also laws recently went into place in New York City requiring employers to disclose a salary range in online postings. So I think that shows which way the legislature might be leaning, at least in the city. And
it's a great point because it's going into effect statewide as of September. Oh. So pay transparency is here in New York.
And that's going to be a growing trend. Is that also to guard against discrimination against one employee over another?
Well, the idea is, we've had a real big trend in evening the playing field when it comes to salaries in the state. So the first way this all started is that there was a ban on asking for salary history. Because the idea is if you're talking about, pay disparity, whether it be cut due to gender or race, if someone starts historically at a lower salary, they may stay as a trajectory lower than their colleagues. And the idea for pay transparency, one of the big pushes of it is the idea that, everyone will know what the target range is for this position so that an individual's own salary history in their own mind or their own idea of what their self-worth may be no longer comes into play. And it really evens the playing field for salaries.
So just to clarify that, an employer should not be asking an employee what they earn at their last or present job.
Yeah, that's correct. You cannot ask people salary history.
Can you ask them what they need in the current position, or is the salary range that you just have to assume they're willing to accept within that salary range?
So, the idea is you post that salary range. Someone's always free to ask for more money. I guess they could also ask for less, but I don't think I've ever seen that before, right? So the idea is that it's a good faith range that the position is worth. So you can't really have that $300,000 to $400,000 salary gap in the range, right? That's not good faith. But the idea is that, it's within a certain range that based on experience, you'd be willing to offer someone for that position.
And I know you mentioned discrimination, Ken. It's interesting that a lot of the cases where these privacy protections come into place are discrimination-related cases, and it's a lot related to context. So you might have an instance where an employer has received a complaint from an employee about discriminatory conduct and puts into place some sort of recording device to see what's going on. In one instance, if the employer has taken several remedial steps and the placement of the camera is just but one of those remedial steps, it might be construed favorably by the court. But in another instance, if someone's complained of discrimination and you maybe put a camera right above their desk, that has been construed as negative and retaliatory. So it's very context specific, and it arises a lot in discrimination contexts.
And do employees have to be treated the same in terms of, let's say, the review process, the pros and cons, the evaluations, a chance to cure any problems?
Yeah, absolutely. You always have to make sure whatever sort of actions you take in the workplace, you're treating all employees equally. Now, that's not to say you can't treat C-suite level employees differently when it comes to benefits or, the special offerings they may have for C-suite level employees. But no, if let's say somebody makes, a request for an accommodation, you have to make sure you treat one employee's request for an accommodation, you go through the same processes you would take for another employee. All employees have to be treated equally.
And in terms of accommodations, are we talking about, let's say, because they're under the weather, they have a disability, they have a family, they have someone else they're taking care of, perhaps a parent or whoever?
Yeah, accommodations can come up in a lot of contexts. You have either under the Americans with Disabilities Act, if they have enough employees, or even under the New York State human rights law, you have obligations to provide accommodations. And that can be due to disability. It can be due to, maybe a religious reason or, some other type of, protected characteristic that requires an accommodation.
Yes, Rachel.
One way this has come up recently is through the use of AI in screening employees. So there's AI technology that can essentially do the job of an HR personnel. But the problem is this technology isn't at the point where it can take into account a reasonable accommodation and whether the applicant would be suited for the job if that reasonable accommodation were provided.
And I'm going to ask you if that AI could be discriminatory in some ways, intentionally or not. But I just want to remind our listeners, we're talking about privacy in the workplace. And as you've heard, there's many interesting issues out there. Our guests are Rachel A. Morgenstern and attorney Nicole E. Osborne. They're both associates with the law firm of Ruskin, Moscow, and Faltischek, which has offices in Uniondale and also in Manhattan. I realize there are many issues out there. What are some of the issues in terms of AI? Problems it can be in hiring and perhaps evaluating employees?
So it's really a developing area, but essentially the AI is just a program and it's designed to screen out certain applicants based on criteria set by the employer. So the answer is yes, the criteria you use might result in certain applicants being screened out who might otherwise have been eligible for the position.
Yes.
We're starting to see some legislation around the use of AI when it comes to employment. It's a very emerging area. New York City recently passed a law and they keep moving back the benchmarks and when it'll go into place. And we've recently received some guidance on how AI can be used in the workplace, where it's appropriate, and how you have to test it to make sure you don't end up with accidental bias in the AI.
And so what could be a potential positive bias for the AI or a negative bias?
Yeah, so we've seen, right, how AI is. It's not like this magic, genie in the sky. It learns. And the information that you feed to it is how it educates itself and continues, to develop how it'll act. So, you have issues where AI has started to take, a negative bias towards individuals who maybe have certain types of names or last names, and it might have a negative bias towards that. So now what the laws are starting to require is that people ensure that this AI is not doing that and that they're checking it and testing it to ensure that these sort of negative biases are not being developed because it's illegal and it's inappropriate.
Could you program the AI so it loves Harvard more than Hofstra?
I guess you could. I'm not an AI engineer by trade, but there's a lot of ways that these AIs can either be purposefully taught certain habits and conditions, or they can pick up on the unknown bias of the person who's programming it.
And the AI is only going to look at certain words or information, good or bad, and just ignore the rest?
It really depends on the AI and how it's been programmed.
What else is new in terms of privacy in the workplace? Well, let's talk about your work computer.
We've all been on a work computer and maybe strayed away from our task
work
at hand. And it's important to remember that when you're on a computer at work, it's not private. There are some recent developments where the employer is required to notify the employee upon hiring if they're monitoring your computer habits. And they also have to, again, inform the employee once annually. So that's a more recent development, though. But ultimately, when you're in the workplace, it's important to keep in mind most of what you do is not private.
And again, even if you're in the hallway, if you're using Wi-Fi, it may not be private.
Yeah, it really depends on the capabilities of your technology department at each company. Some are much more sophisticated than other and have web filtering or web tracking. So it really does depend on a company by company basis. But yeah, there are some places that are able to capture information of how people are using internet usage at the companies. People do have to be wary.
And of course, they also may be using it to see if you're really working. They're not so much interested in what you're doing. They just want to make sure you're working.
Well, that's a really hot area at the moment is, either keystroke tracking or, a lot of the technology that company put in place during this remote work period due to COVID is, were people aware of how they were going to be monitored, whether the mouse is moving. And some companies now can even know if you've downloaded certain applications that make it seem like your mouse is moved or keep you active on, Microsoft Teams or things. And they're able to start and track employees that are doing that. So companies have a lot more visibility into the work you're doing than they would have even 5 years ago.
And Rachel, what about employees recording superiors or, workers recording other employees?
When you consider recording in the workplace, context is key. And whether you're recording your superior or your colleague, if you are trying to document discriminatory conduct, you're protected. And aside from that, it's really a matter of internal policies within the company. Again, if you record your colleague, it may be legal, but it may create an intimidating environment. It may alienate your colleagues. And for that reason, a lot of employers have begun to incorporate policies within their manuals that prohibit recording in the workplace. And they notify their employees about this not only to prevent the recording, but to, I think, ensure a happy working environment. Even though technically you're allowed to, it's not necessarily advisable.
Yeah, and you have to be really careful with prohibiting recording in the workplace because the National Labor Relations Board has put out certain guidance that employees are allowed to record in the workplace, and it could be for, unionization purposes or other protected activity. And, there are times when you might be able to carve out like videoing in areas that have highly confidential information, but you have to make sure it's backed up by a reason other than just not wanting recording.
And when we say recording, we're talking about audio or video or both?
Well, for the purposes of what we're discussing here about employee recordings, we're discussing both. When we talk about employer recordings, only video recording is permissible. You can't have audio recording from security cameras.
I know that both of you help employers to write employee handbooks and to update them, which is very important as laws or policies change. So, Nicole, what are some important things that should be covered in a handbook, and what are some things employees may want to update in their handbook?
It's really important that your handbook reflects how your company operates. So it should have everything from when payday is, how overtime works, all, the real practical practices of the company, all the way to the legally mandated type of topic. So you have to make sure you have your sexual harassment policy in there. You want to make sure you have a no expectation of privacy policy to cover a lot of the topics we've been discussing today. Your paid family leave policy. And really, it's important to note we've really been focused on New York state law here today. And, you might have a business that has employees in a lot of different states, and it's especially important then that you make sure that, something like, recording employees with video only may be permissible in New York, where it might not be permissible in another state. So you really have to make sure your employee handbooks address all the types of issues you may have when it comes to your employees, because not only does it help employees understand what's expected of them in the workplace, what rights they have in the workplace. An employee handbook is really an employer's best defense when it may come to certain employee claims made against them.
Okay, I'd like to remind our listeners we're talking about privacy in the workplace, or in some cases, the lack thereof. Our guests are attorneys Nicole Osborne and Rachel Morgenstern with the firm of Ruskin, Moscow, and Faltischek, with offices both in Uniondale and New York. You both, Nicole, you mentioned privacy before, and is that something that also should be addressed, or the lack thereof, in that employee handbook, or updated to reflect the latest protocols?
Sure. Yeah. So, I believe every employee handbook should have a no expectation of privacy policy. And what it sets forth is making employees aware that they have no expectation of privacy. Every once in a while, our policy names are pretty self-explanatory. But what it does is it explains that we'll track your internet usage, we'll track your emails, we'll track your phone calls. And knowing that New York actually is a little behind when it comes on to privacy rights in the workplace for employees. We have states like California with the California Consumer Privacy Act and the California Protection Rights Act. And what it does is it actually increases privacy rights for all individuals when it comes to companies collecting their information, but also provides additional rights to employees. So New York does have some protections, but we're seeing there's a bigger trend of privacy nationwide.
How are law firms doing with this? Because law firms are employers too, and their employees, their partners, their staff, support staff have concerns. The same rules apply to them. Are there any other practices you mentioned that should be adopted by law firms?
An employer is an employer, right? So whether they're a law firm or they're another type of business, all these types of rules apply. I guess for a law firm, you'd also just want to remind everyone, not just lawyers, of their confidentiality obligations to our clients, or any sort of other ethical obligations they may have. But an employer is an employer.
And that confidentiality obligation is very important, especially to remind the support staff of that, the partners, and the associates as well. What are some issues that I know? Tell us about your firm's website, where I know, Rachel, you had an interesting article that was, that should be on the website with information for employers. And what other information is on your firm website?
Yes, so we work at Ruskin, Moscow, Faltischek. It's been around since, I believe, the late 1960s, and we provide services in all major practice areas. So corporate law, commercial litigation, real estate, trusts and estates. We ourselves, myself and Nicole, we're in the employment and labor law practice group, and our website will have descriptions of all the different types of law we provide. It has links to the employment and labor law practice group blog, which is where we update our clients and contacts as to the latest developments in that area.
And there's a lot of information there of value to lawyers, to employers, to employees as well.
Absolutely.
And just give us the website.
It's www.rmfpc.com.
And anything you'd like to add about what's available on the website, Nicole?
Yeah, no, our firm works really hard to put out a lot of content. So, whether it be an article on new securities rules, or, updates in the CPLR litigation, or we have so much content when it comes to employment and, the changing rules and laws. There's a lot of great articles, and we have the great labor and employment blog, that there's good content out there for anyone, regardless of whether they're a lawyer, an employer, or an employee.
And what do you both think are going to be some future developments in the next few years concerning employee or employer rights in the workplace?
I've read recently that there are developments in the area of non-competition clauses and non-competition agreements. Nicole, I think you might have mentioned this.
Yeah, so, there was Biden's executive order last year that directed the Federal Trade Commission to really put out guidance on how non-competition agreements should work. And really what those are is the idea that when an employee leaves the workplace, that they can't compete against an employer for a certain period of time. They're legal in New York, although they're highly disfavored by the courts, and you have to really prove that there's a purpose for this non-competition obligation. But I think that's a great area that I think we're going to see a lot of traction from, whether it be continuing to see the courts analyze it or to see what the Federal Trade Commission does due to Biden's executive order.
And part depends on the scope of that agreement, in length and territory and in areas that you may be barred from non-competing.
I believe traditionally it will depend on the scope in terms of enforceability. But as far as I know, there's been some discussion of late of barring them outright.
And a lot of states have taken that step already. Some states, they're wholly illegal already. And the executive order, the idea is that it is supposedly going to ban non-competition agreements for anything outside of like after you sell a business, but we'll see.
And what about non-disparagement clauses?
I have never really heard anything negative about non-disparagement clauses. More often than not, they end up being mutual between the employer and the employee. Neither can say anything disparaging about them.
But they are still allowed to make a complaint to an administrative agency or to a district attorney if there's some claim to be evaluated.
Oh, absolutely. There's usually always a carve-out for whether it be complaining to an administrative agency, a court order, or something like that.
And just briefly, how else do you and your firm help employers deal with the many employment issues out there, aside from the employment manual?
Yeah, so I like to always say we help, employers from soup to nuts, right? So we do everything, from any phase of the employer-employee relationship, whether that be, creating employment agreements, confidentiality agreements, to helping employers manage workplace issues, all the way to what really Rachel does a lot of, the employment litigation. When something goes bad, managing that litigation, whether it be at an administrative level or in the courtroom.
And sometimes it's resolved through ADR, administrative proceedings, as opposed to lawsuits.
Yes, we work a lot in ADR, but often we jump in right when someone receives a complaint and the lawsuit begins. And our job is to take that person from the complaint through to trial if necessary.
And you also give them advice before there's a problem about the hiring process, about the conditions of employment, about flexibility in dealing with different issues that come up in the workplace.
Absolutely. One of the best times to consult a lawyer is before you have a problem. It's the best way to avoid the costly litigation that we see so often.
And with litigation, sometimes one party is not happy, be it the employee or the employer.
Oh, usually in litigation, neither party is happy.
But you can help them prevent and resolve many of these problems.
Yes, absolutely.
And just give us your website again.
www.rmfpc.com.
And I would like to thank Rachel Morgenstern and Nicole Osborne with the law firm of Ruskin, Moscou, and Faltischek. As you heard, their website is rmfpc.com. And if you missed any portion of the program or you want to listen to it again, it's available as a podcast by going to nccradio.org. Please keep in mind whatever you've heard is just intended to be legal information and not advice about any particular situation or law. You can only obtain that through a consultation with Rachel Morgenstern or Nicole Osborne or some other qualified employment law attorney. And please feel free to join us again next week at this same time here on 90.3 WHPC, the voice of Nassau Community College in Garden City, New York, for another program on Law You Should Know.